Next up is a discussion about legal issues and liability surrounding civilian oversight, interaction, and participation with civilians with law enforcement agencies. Keep in mind that our law enforcement agencies in the United States are paramilitary in nature. Not military, but paramilitary in nature. We are not a police state. Unlike other countries that are police states are purely military type policing styles, in our country we have civilian participation. We have civilian oversight. Ultimately, every law enforcement agency reports to a civilian, and that's the way our democracy works. And I should say to some civilian type oversight. So if you're a police department, you obviously report to the chief of police, but that chief of police reports to a city manager or a director of public safety. And those individuals are appointed by their jobs, generally by commissioners or the mayor or the board of county commissioners. So there is civilian oversight in every law enforcement agency. On a federal level, the administrative heads of the DEA, the FBI, and the Department of Justice are appointed by the president, and they are civilians. So we do believe in this control of police power by civilian oversight. So we have to address this area of the law. Now, our first discussion's dealing with public records. Everything that a law enforcement agency creates, whether it's digital in form or hard copy in form, emails or what have you, is public record. However, it may not always be disclosed under the public records laws. We have a federal and state public records laws. Let's first talk about the Federal Freedom of Information Act. That applies to federal law enforcement agencies, not state, but federal. You often hear it called FOIA, F-O-I-A. This is a law that gives you the right to access information from the federal government. So it doesn't just apply to law enforcement agencies, but it applies to all the federal government agencies. It's often described as the law that keeps citizens in the know about their government. Under a FOIA, agencies must disclose any information that is requested unless that information is protected from public disclosure. FOIA also requires that agencies automatically disclose certain information, including frequently requested records. It was enacted in 1966, since it's a federal law, and it gives a person a right to review records. And if the agency doesn't comply and doesn't have a valid reason for redaction or rejection of the request, it is enforceable in federal court. An action can be filed against the specific agency. And if the court agrees, the judge agrees it should be disclosed, then the complaining party, the petitioner, which is the general public or a person from the general public, gets their attorney's fees and cost paid by the government. And it could be a costly battle, a costly mistake for an agency on a federal level not to turn over documents. Now, there are certain exemptions. There are 9 exemptions under this particular law. If you do the research, actually, there's carved out 9 exemptions. And then there's 3 special law enforcement record exclusions. So certain records dealing with law enforcement do not have to be disclosed. Now, on a state level, each state is a little different. Some states have extreme public records laws and statutes, whereas other states have much less. Under Florida law, it's extreme. We call it the Florida Sunshine Act. Basically, it requires public open meetings, and then it addresses the public records. There are extreme rights to public records. So each state's a little different. Let's just talk about Florida for an example here. And Florida's rights to public records is codified in not only its constitution, its state constitution, but also in its state statutes, and specifically Chapter 119 of the Florida state statutes. It allows for one of the most liberal access to state and municipal records. It provides for attorney's fees and costs if a party has to file an action to enforce their request, and they prevail. Now, it does provide some law enforcement exemptions. For example, information about law enforcement and other governmental workers are restricted from release, such as phone numbers, their addresses, their family phone numbers, their names and addresses, school locations of their family members. So it's not a complete release of information, but generally it's very liberal. If you take a look at 119.071, it talks about the various exemptions out there. Everything is disclosable except, and then it goes into various exemptions. One of the exceptions that's interesting in Florida is that sealed bids, proposals, and replies in the negotiations in selecting a vendor for a bid, and we talked about the bidding process and government procurement in a previous discussion for law enforcement agencies, but those are all held confidential until the bid is actually awarded. So that allows these committees to get together and review the bids and exchange information between themselves to select the highest qualified bidder. And then it becomes usually public, well, it's public record, but then it becomes disclosable. Other types of exemptions under Florida law are criminal intelligence information and criminal investigative information if it falls under certain parameters, and any information revealing surveillance techniques or procedures or personnel is exempt from disclosure. Even though it's public record, it is exempt. Keep in mind there's a difference between the two. Public records are all around. Everything we generate as law enforcement agencies and personnel, that's public record. But is it disclosable? Is another question. So these statutes are very detailed, and generally they start out by saying everything is disclosable except for the following, and then it starts listing the items that are exempt from public disclosure. Over time, a lot of exempt items lose their exemption, though, because there's no need for security or surveillance techniques ultimately to be protected forever, because eventually they're learned or it's revealed out there in the field. But keep in mind, you have to conform to public records requests. The way I like to explain it to the different majors and colonels that I deal with is that these documents are the public's property. They may not be able to see it right away, but they do get a right to see it eventually. If an exemption applies, we redact the copies to the extent that the exemption shields the information. But generally, these are the public's documents. They have a right to see them, and you have to run your agency with that philosophy. You report to civilians, these are the civilians' documents. Now, there is another interface with the public that often causes friction with law enforcement, and that's outside oversight. Again, we talked about in a previous discussion how we would prefer internal controls, internal mechanisms to control our workforce. In other words, let the police police themselves. But there are times when outside oversight comes into play, and these generally are civilian run. Specifically, let's talk about consent judgments and federal judgments. They're both generally federal. Sometimes they're state, but generally they're federal judgments. Consent judgments are when the parties enter an agreement during federal litigation, whereas a federal judgment is when the judge actually signs an order. It may or may not be reached by amicable resolution between the parties, but the federal judge signs an order. For instance, Department of Justice has done several investigations in 2015 against the Cleveland Police Department, Philadelphia's Police Department, Ferguson, Missouri's Police Department, and some others. And generally, their findings showed a pattern or practice of discrimination or bias-based policing or civil rights violations. And once they publish those reports, they generally sit down with the agency that's involved and say, okay, this is how you fix the problem. And they appoint a federal oversight person or board or a collection of people voluntarily. And if it's reached voluntarily and no lawsuits involved, then great. They enter a formal agreement as such. But generally what happens is that the federal government files a case. The Department of Justice files a case, a federal case, seeking enforcement of remedial measures against the subject local municipality or state agency. And then the judge hears the case, and if the parties reach an agreement, they draw it up and they submit it for the judge to enforce it, and that's called a consent judgment. Whereas if the parties during the litigation, the federal litigation, can't come to an agreement, ultimately the judge will make a decision. Usually judges do side with some civil oversight. Now these agreements, whether federally mandated or via consent judgments, which the judge enforces the parties' agreements, usually dictates reporting requirements. Every month or every quarter, or at least every year, data has to be collected and shared and distributed. It establishes an outside monitor or auditor. Sometimes they're called an ombudsman. But generally, it's an outside individual that will review the data and have the power and authority to collect their own data and research what's going on. It allows for active review by court-appointed authorities, and so these outside monitors or auditors have a federal judge behind them. They're appointed by the federal judge usually, and that gives them force and effect and authority to actually either run the department. If it's that bad, they can take over the department, or just monitor and regulate it and report to the judge if and when another violation occurs, and recommendations on how to clean up the agency. That's often a big one. Law enforcement and correctional agencies lose some of their autonomy and sovereignty when this occurs, because an outsider takes control, if you will, of the reins or participates in the management decisions and auditing and regulating and monitoring of the workforce of a subject agency. Often ordered if proven civil rights pattern or practice is established. Again, we talked about that the Department of Justice preliminarily does an initial investigation and comes to a written report which they release because it's public records. These consent judgments are final judgments of monitors and oversight and auditors, and plans to fix the problem could last for years. Every large agency at least has been investigated, probably at least once, and many of them are or have been under consent judgments. The LA Police Department was under a consent judgment for 12 or 15 years, I can't remember, but a very, very long time. And it was a major one because it really required lots of changes and monitoring and regulating. They still may be on it, but there was a movement to try to discharge it. Discharge basically means when the agency has fulfilled its commitment, they believe they fixed the problem, they try to get out from under the consent judgment, terminate it because it's no longer needed. The Broward County Sheriff's Department has a consent judgment against it. It's been under consent judgment for, I'm estimating, but probably 20 years, and it deals specifically with the corrections department, the jail system. We are a very large county, and we have very large jail population on any given day, and we're capped out at the rates of the amount of prisoners we can put into jail cells. And if we go over that limit, we have an emergency, believe it or not, we have an emergency jail center already set up and ready to be activated. It's an empty building, quite a few empty buildings. And it is a jail that we use for overflow purposes, and it's activated if and when we reach certain limits. Why did this consent judgment come about? It's actually called the Carruthers case. It was a famous case, at least locally here, in which the federal judge mandated that we improve our prison conditions and limit overcrowding because it was very, very bad things that were happening. Of course, the sheriff's department was underfunded, but prior sheriffs way back when were not providing the essential housing responsibilities and fulfilling them course, a lot of it has to do with the county itself. It's not funding the jail system properly. So this mandates the funding. It's been around for a very, very long time. So every agency faces these things, but the legal liabilities are obvious. If a judge says do it, you got to do it. If a consent judgment is entered into voluntarily, you have to fulfill those terms. And if you ever want to change them, you have to go to the federal judge who initially ordered both parties to abide by their agreement, i.e. their consent, through a consent judgment. You have to go to a judge to modify it. And usually the legal liability surrounding this is if you breach it, you could be held for attorney's fees and costs. Also, it doesn't look good in the public relations realm if you're breaching court orders. And there may be liability. If the judge says only 3 people per cell and you put 6 in and something happens, a riot or a fight or a fire or something along those lines and somebody's injured, you're in violation of a consent judgment or a federal judgment, and there's a lot of liability there. So you have to follow these consent judgments. Normally my advice is if the Department of Justice says something, you might as well cooperate because they're going to start up a case and it becomes very public, and you'd better, and it's probably more advantageous for agencies to cooperate and come to something and create a system that they can live with rather than it being imposed upon them. Civilian review boards are a little bit different. These are government-sponsored, if not government agencies, on a municipal level, maybe on a county level, but generally a municipal level, that are staffed and run by civilians, many times volunteers. And what they do is they advise police departments. If not, some of them do have powers to investigate. There's over 200 of these in the United States, but there's no uniform structure. Sometimes they're a board of individuals or a council of individuals. They have different structures and powers. These kinds of civilian review boards are more popular in Europe than in the United States, but they're popularity is growing, and the United States Department of Justice promotes their growth and recommends that they do exist. They do differ in power and authority. There are generally, I would say most are just advisory in nature. What that means is they review internal affairs departments and review policies and procedures of police departments and make recommendations on improvement. But their recommendations are very public. They have hearings and they have input from the public, so it's very visible, and they kind of are seen as the bridge between the police department and the general public. Keep in mind, though, any good law enforcement agency that's run properly and managing crises and is responsive to the community generally don't have these around. There is no need for a bridge because they interface with the community successfully. These types of review boards generally are put in place as a reactionary type response by a city or a county. For example, Ferguson, Missouri, the Michael Brown incident. Immediately, I would say within 5 or 6 months after the event, the city announced they were going to establish a civilian review board on their own. Now, they kind of knew this was going to be mandated on them by the Department of Justice, but they went ahead and took the approach of, hey, let's create one of these boards. And it was in reaction, obviously, to the community's uproar. So these particular boards, again, have extreme different degrees of power and authority. Most boards are advisory in nature, whereas some boards have subpoena power. I know that in Florida we have 2 civilian boards, one in Miami and one in Key West, that have subpoena power. They can actually compel people to come before them, them and officers to come before them. But they only have recommendations. They can only give recommendations on how to fix the problem. They can't enforce discipline. But then there's other civilian review boards that have extreme power. They actually sit on top of the police department or the police chief, and they hear appeals of decisions of police chiefs, such as the city of Milwaukee has a very, very strong police and fire review board. So they combine the two. and they actually hire the police chief, or make recommendations, I should say, to the mayor for the police chief, and shortlist applicants. And they, boy, are heavily involved in the operations of those two, the fire and police. The Los Angeles Police Department has a inspector general and a whole department which falls under the police commission. And the police commission is all made up of civilians appointed by the mayor and commissioners, and they actually oversee the police department. Again, they shortlist police chiefs to the mayor for appointment and commission, and they hear appeals. If the police chief fires someone, then the appeal is heard by them. They're very, very powerful. So it all depends on which city and which degree of authority and power that these boards or councils have, which will dictate how much, basically how much you have to interface with them. Many cities and municipalities don't even have them. I would say the majority don't. But there's a growing trend to set them up after the fact. It's kind of like an after-the-fact reaction by civilian boards of commissioners or mayors. My advice to you is that, first of all, if there is a movement to set these up, don't try to squash it, even though our first gut feeling or reaction as law enforcement agents or law enforcement managers or supervisors is that you don't want more red tape. You don't want to have to report to another party. You don't want to lose any degree of sovereignty. That's a natural reaction by the police department. However, my experience over the years, and I've dealt with a lot of these boards, my experience over the years is that ultimately, if there's a movement, there's something wrong with the way the public is perceiving your interface with them. And if you can't fix it, these boards ultimately will be put in place. They'll be mandated. And you've heard the phrase resistance is futile, from Star Trek and the Borg. My advice is resistance is futile. Try to sit down with the community leaders, sit down with the mayor and commissioners, and say, all right, you obviously want this. We'll go ahead and appreciate and accept your recommendation, but let's build one that we can both live with. In other words, if it's a committee of 9, 3 are appointed by the chief of police. Or if there's a committee of 5, 1 is appointed by the chief of police, 1 is appointed by the union representatives, the police union representatives, and the rest are civilians. Or, try to suggest an advisory role rather than a inspector general role of these agencies, or only allow these agencies to give advice, not investigate. Because generally civilians are not well prepared to investigate anyway, and they don't. And studies have shown that many of their investigations are not always sound because they're not armed with these tools. If and when these agencies or civilian review boards are put in place, you should always, always, always assign a liaison. Don't shut them out. Don't ignore them. Assign a liaison to them so that this liaison can train the civilian review board so that they understand police policies and procedures, and they understand what they're reading when they review internal affairs reports and make their recommendations. Set up a ride-along, a robust ride-along program so that you educate these members of these civilian review boards. And usually the members rotate on and off, and so you constantly have to keep up to date and educate them. Be at the board meeting. Let this liaison member be at the board meeting. Be visible in uniform to appease these boards and make them feel that they're part of the solution. If you just totally shut them down and ignore them, that's probably the worst thing you can do, because then they're going to incite even more regulation. Remember, they're seen as the face of the public when they're set up. So some of the legal issues involved in these boards, as we've just discussed, is that from a legal advisor viewpoint, many legal advisors, counterparts in other agencies, they feel that these civilian review boards cause problems, or civilian investigative panels cause problems because they uncover the dirty laundry. They launch investigations and ultimately expose the city to liability. So they create liability, these boards. But that's not always my impression of them. But that's kind of, and I would say that's kind of a short-minded impression of them. Normally, if you head off at the pass any liability and you correct the interworkings of your department, these review boards generally don't have anything to do. I see them as an ally. Sometimes you can even leverage their influence, and if it's the chief of police or the sheriff who's under them, who he or she can say, hey, it's not me, it's the review board. I got to do this what the review board says. I want to take them in their opinions to heart. This may be an out for a sheriff or a chief of police when dealing with the unions or dealing with factions out there or other stakeholders. So keep in mind there is a lot of liability surrounding civilian review boards, lots of responsibility once they're set up. You want to keep them independent as much as possible because that's their purpose, is to be independent. Otherwise, they lose their legitimacy in the public's eye, and they're a waste of time and money. Yes, they do create liability to some extent. They do find the dirty laundry. They do air it out in the press because their meetings are so public. But you know what? That's why we are a civilian police force. We report to civilians. We participate. We allow them to participate in law enforcement to some degree. And so, there's no really changing that fundamental democratic type philosophy of paramilitary police forces in a democracy. The largest group, NACOLE, or NACOLE, NACOLE.org, you can go to their website. They generally are the trade union, if you will, the group of Association of Civilian Oversight of Law Enforcement Agencies. And they have a very active website, a very informative website if you want to go there and review how these boards are set up over time and their different powers and the different events. They have like a yearly meeting or a yearly seminar for several days to train members and to exchange information. Now, another issue with the public interfacing or trying to police the police sometimes, as they would say, is public filming of police interactions. This seems to really get under a lot of people's nerves, or a lot of officers or sheriff's deputies on the road, and I hear your pain. I've done many ride-alongs, and I get out of a unit, a marked unit, and immediately I see 2 or 3 handheld phones videotaping me. They really don't know who I am. I'm not dressed in a uniform. I'm in a suit and tie. If anything, I'm more civilian than law enforcement. But they start filming me right away. And it does get a little aggravating, I will tell you. But it is what it is. The courts, the federal courts, have generally cited and ruled that this is a constitutional right. They have a right to film. The public has a right to film government workers when they're working. If you don't like it, then go to a private security firm or go and work for a private company. Don't be a public servant then. I mean, I guess is the response. It sounds harsh, but that's in reality, it goes hand in glove with being a public servant. And federal courts, again, have all generally held this is a constitutional right. It's a protected activity and valued as a way to regulate police departments. However, with that said, there are exceptions to every rule. Some people call them loopholes. We call them exceptions in the law. And if the handheld device is recording and it records evidence of a crime scene, or a crime, pretty severe crime, misdemeanors on up, not traffic infractions though, but generally if it is evidence of a crime, it actually documents crime, you can go ahead and take it temporarily, get a warrant to download the contents, and then return it. That's allowable. There are also reasonable time, place restrictions on filming. And I know in our agency you cannot film inside the prison. We don't want people to see the interior hallways and camera positions and security personnel and procedures documented for all, because that's a security concern. Certain sensitive areas. We don't want undercover agents inside our police department filmed. If the filmer is causing a public disruption, maybe standing in the middle of the street where cars have to go around them as they're filming law enforcement, that's a reasonable restriction, is to make them, remove them, and put them on the sidewalk somewhere. No filming in, for example, the TSA areas at the airport. Generally, filming is not allowed there. There are security issues. These are all considered reasonable time and place restrictions. They're not absolutely barring videos of law enforcement officers in action, but there are reasonable time and place restrictions in which law enforcement agencies can adopt. If the video or photographer is standing in the way of an active scene or arrest, getting in the way, then you can stop them from filming and tell them to move away. The liability issues here, of course, are seizing a handheld device without authority, are forcing members of the public to stop filming when there is no reasonable time or place restriction at hand. In other words, you didn't have a basis for stopping them from filming. Keep in mind, you need a warrant. There's case law out of the U.S. Supreme Court as of 2014. You need a warrant to search the contents of a cell phone, unless there's exigent circumstances. Generally, you need a warrant. If you don't, then you violated a right. That could be a 1983 action against an agency. If you violate people's rights to film, or if you seize their electronic devices and start searching them without a warrant and no probable cause to believe that it has evidence of a crime on it, or it is evidence of a crime. You can't retaliate against a person filming. In other words, load them up with tickets, traffic tickets for doing it. That would be retaliation. So just keep in mind, all I can say is you have to pack your patience when you get out into the road patrol, motors, or interfacing on a daily basis out there on the street, and expect that you're being filmed. And in fact, that's probably in reality truthful. Everything we do out there in the streets now is being filmed by somebody with a handheld device, or by cameras up in the red light cameras all around are filming, and then the city has cameras, and the county has mounted cameras all over watching traffic flows. For chances are, most of your day is being documented on video from helicopters and news helicopters. So get used to it. The bottom line is, it is the way it is, and you should always act as if you are being videotaped, and you should always accept that there is a constitutional right for civilians to videotape you in most circumstances. Maybe not in a hostage situation. They don't want to streamline the video onto the internet and then the hostage taker inside the building sees it. That would be a problem. So that would be a reasonable time, place restriction. Body cameras seem to be a lot of promotion for them. They see a lot of the public believe that they will be the silver bullet to resolve all of the problems that they perceive law enforcement using excessive force. It would document the scene and the event. After Ferguson, Missouri, and Michael Brown incident, there's a big push for body cameras. But the problem and the legal liability issues surrounding body cameras is that they don't always tell an accurate story. You only see what the camera records, and you only see, it's like a flashlight in a dark room. When you shine it, you only see parts of the room. You don't see the full story. There are privacy concerns. Could you imagine every officer having a body camera on 24 hours a day, and when they arrive at a domestic dispute at night, they have to walk into the house and they see the family, the kids crying, the mom or the female or the dad, the husband, beat up That's privacy concerns. What do you do with the video footage? They haven't consented to the public seeing all of that, especially in public records requests. What do you do? So there are privacy concerns here of having body cameras on 24 hours a day. However, it seems like that is the movement towards these particular devices. The federal government is promoting them and giving out grants. Many local municipality commissioners and mayors, they're all starting to look for funding for this. I know in South Florida, the Miami Police Department and Miami-Dade Police Departments are all adopting policies and procedures and funding and acquiring these cameras. Our particular agency is looking into it. I'm a big believer that if you see a trend out there, it's ultimately going to happen. So why not preempt it and do it on your own, especially if you're an elected official. If you're a sheriff in charge of a large force, you might as well take the bull by the horns and get ahead of the parade and do it, because it's probably going to be mandated on you eventually. You ask for the funding from the commissioners, and they would be in an awkward position not to fund it. And then you put it in place. You create rules and regulations that you can live with. Otherwise, you may be rules and regulations may be imposed on you. You had no way to participate in their making if you don't do it yourself. So I'm a firm believer that the body cameras may not be the silver bullet, but they will be helpful at times, and it's going to happen anyway. So you might as well go ahead and embrace the technology and create strong policies, clearly written, and train the workforce on how and when these cameras are to be turned on and how and when these cameras are to be turned off. Also, how to deal with public records and redaction of these recordings, and how long will you store the recordings. In Florida, they only have to be stored for 30 days, unless they involve being a piece of evidence in a criminal case, or the department is put on notice that there's a public records request on them. You can't dispose of them. But there's data storage issues. The cameras themselves are not so expensive anymore. You can go online and get a camera really cheap, a body camera. These devices are not very expensive. However, the data storage is very expensive, and they take up a lot of space, and so that's generally the cost that you have to work out. But make sure you have sound policies and procedures, and you enforce them. If an officer doesn't follow them, you must sanction. Don't show preference to one officer over another, and don't let it slide. It may sound, the officers or deputies may say, "Oh, I just forgot to turn it on, or it was a mistake." Set up a verbal warning, written warning, staggered, accelerated, disciplinary type reaction, and take it seriously and enforce it. Otherwise, the union is going to complain if you don't enforce it properly. Other issues here in this area is legal citizen police forces in Virginia and other states, like Virginia and Maryland, actually have laws, state laws, that say civilians can apply for and carry a gun and a badge and make arrests just like police officers, believe it or not. In Virginia, they're called Special Conservators of the Peace, SCOPs. In my opinion, I think this is a recipe for disaster, but some states allow private citizens to actually patrol the streets and have authority as police officers without being members of the police department and with little training. Again, I think this is a train wreck waiting to happen. What are the legal liabilities to the police department itself? Well, obviously, they don't work for the police department. So you may think, oh, it's not our problem. But it is, because they do put out, if the public's confused as to who they are and who the legitimate police are, it gives everybody a bad name, especially if these untrained individuals do something wrong out there. Or if the deputies or police officers out on a scene come across one of these individuals who's duly licensed by the state now to do what they're doing, there's confusion. You may have friendly fire. So be aware that if your state allows these types of individuals to actually exert police power, then you should train your force to be aware of them. Train your force about the laws surrounding them so there's no misunderstanding. Obviously, there's going to be a rub between, I say, legitimate police and then these particular individuals. But you have to work out those difficulties. Again, I'm not a big proponent of these laws, but they do exist out there. Sovereign citizens. This is a growing trend out there. There seems to be a movement of independence by individuals, saying that they don't like the government, and the government has no authority over them. They are not going to submit to the authority of an officer or police, or the police agency, or deputies or sheriffs, and there's nobody who can tell them what to do, basically. They don't believe in the government. This is a problem. And if you engage them and join them down the rabbit hole, because they have lots of theories of why the current government is illegitimate, you do find yourself in a wonderland. So generally, you have to train your force that these people do exist. And these people must be treated particularly with sensitivity. Don't enter verbal arguments or legal theories of why their thought process is not complete or improper, but you do have to enforce the law. And they don't even believe in the court system, so when you do cite them, chances are they don't even show up. But the big problem in the liability in this area is often they create their own, in their minds, legal documents, and they place liens and judgments and notices on public record. They do the filings themselves. And that could cloud title to different officers' houses or property. I've seen this where they actually file a lien or a notice against the property. And they have very official-looking documents which are worthless. But then it causes problems because these documents are filed on the public record. So some states have actually passed laws, like Florida has passed a statute in 2014, I believe, and it basically says the agency, the employer, can sue these individuals on behalf of the employee, i.e. the deputy or the road officer, who gets damaged by these fake filings on the public records. So you have to be cautious when dealing with these individuals. Confrontations can escalate very quickly. You should have supervisors at least trained on dealing with these individuals. They tend to stick out like a sore thumb. Once they're pulled over, they start reciting the Uniform Commercial Code, which has no application to police work, but they start citing it. They start citing how zip codes are illegal, and they won't give the zip code, and they may not even give their proper address or name to you. They generally don't respond. They don't respect authority. They don't believe in the court system, and some of them have even set up their own court systems. So it is, to say the least, problematic for police officers to deal with these individuals. There are other initiative programs that we need to just touch upon here in this area. There are healthy programs to promote in every agency and in every community, such as civilian ride-along programs. This is a good chance for the civilians to ride with the police officers, see the day-to-day interaction and the good that these officers do. Too often is the case where the press really concentrates on the bad incidents, or where we fall short in our policing efforts, our professionalism. And so these ride-alongs are very encouraging. You encourage the public to do them because they're educational in nature. However, if you're going to have a ride-along, make sure you have the proper waivers. Make sure you do the proper background checks, at least the very basic background checks of people participating in these programs. Make sure that you don't put them in a extremely hazardous situation. And if there is a situation, make sure that they sit in the vehicle. They don't come out unless you allow them to. So you remember, they're your problem then. You're responsible for their health and well-being. So you don't want a civilian to be put into a situation that is dangerous when they're doing a ride-along. make sure that they don't represent themselves as law enforcement. They don't wear any insignias that would confuse the public. Make sure they're given direction before the ride along as to if something happens, this is what they do. Or they're told, not to carry any firearms, of course, and not to wear any badges, things along those lines. Citizen watch programs and procedures. These are also very, very helpful for crime suppression, and a great way to educate the force and the community with each other's difficulties and problems, and it's a good way to unite the force with the community that they serve. Citizen police academies, again, these generally are a week long or maybe even 10 weeks long. I've seen them, and again, it's a good way to educate the citizens on the police agency, their agency, how their tax dollars are spent. Often inside these police academies is a day-long ride-along program. So these are also very healthy. But just make sure, legally speaking, the liabilities are generally waivers need to be filled out so that if they participate in dangerous activities, they know what they're getting into. And they waive rights and claims against the agency if something goes wrong. Or they indemnify the agency. If they set up their own little private security force and they want to participate in policing within their community, they should indemnify the agency. Make sure that generally that the participants are not armed, at least in ride-alongs and at the civilian police academies. In crime watch programs, my recommendation is that at most they're given a radio, but no other types of firearms or stun guns or things like that, because that all opens up the agency to liability.